Judge, we have a case that indicates that the issue here
Thank you.
State of Florida versus Horowitz. 191 Southern 3rd, 429. It's a Supreme Court of Florida case, Judge, from 2016. Judge, in that case... Oh, sure. Must be becoming soft-spoken in my old age. Judge, in this case, the defendant was convicted of first-degree murder with a firearm. During the trial, the state repeatedly elicited testimony from law enforcement witnesses that the defendant remained silent following the murder, but prior to her formal arrest. The state then emphasized the silence in closing argument by arguing that the jury could consider the defendant's pre-arrest, pre-Miranda silence as evidence of her consciousness of guilt. That is precisely the argument that the state made when we were arguing our objection at the bench, that the state was trying to establish consciousness of guilt. With respect to Mr. Rodgers, the court found that the pre-Miranda silence as substantive evidence of guilt when the defendant has not testified at trial was unconstitutional. The Fourth District Court of Appeal concluded that the state could not use evidence of this silence as substantive evidence of guilt, and the issue was therefore certified.
These are the other copies of orders. I'm guessing one of those is for us.
We are working on that right now.
State needs a moment.
No, Your Honor. The issue in the instant case, in the case of State of Florida versus Rodgers, is distinguishable. A little bit of Horvitz I was able to read while I was standing here. We're not using Mr. Rodgers' invocation. We're not using any pre-arrest, pre-Miranda silence. It's actually the opposite. He wasn't silent. He spoke. He just wouldn't allow the detective to record the statement. And that's what the issue is. The issue is not that he refused to talk. He did talk. You heard the testimony. There was a conversation. It was voluntary. We put in the evidence of the voluntariness of the statement. So the issue is not whether or not he remained silent. It's not our position that he remained silent. He did at some point, ask not to talk, which we agree. It's not admissible. It's not relevant. What is relevant is when the officer wanted to record Mr. Rodgers' discussion, Mr. Rodgers refused to be recorded, but wanted to have a conversation, which they did. And that's what the issue is. And our situation is distinguishable from counsel's recitation of the facts in Horvitz. I do have, and I apologize to the court because I was in the process of printing it, and we were both printing, so my copies, I think, went somewhere. But I have Fernandez. Now here, this issue is a case where a defendant waived Miranda. However, the detective who was questioning him wanted to formalize the statement by recording it, and the defendant would not allow it to be recorded. Now, it's not completely on all fours, again, with our instant situation, but here the third DCA says the defendant's refusal to formalize the statement is admissible. Here, the defendant waived Miranda and agreed to talk. In our instant situation, there was no Miranda given because the defendant was not in custody. There was no need to Mirandize him. However, he had agreed to talk and refused, after agreeing to talk, to allow the officer to formalize it with a recording. And that's what the issue is in our instant case of State v. Rodgers. We would respectfully submit that the defendant's refusal to allow the recording is admissible. However, his indication towards the end of the conversation that he did not want to talk anymore is not admissible. I'm sorry, and I didn't cite Fernandez. It's Fernandez, 786 Southern 2nd, 38, 2001, 3rd District Court of Appeal.
Okay.
Judge, again, this is done. This question was asked to whether or not to record when Mr. Rodgers had absolutely no obligation to speak to the police.
Okay. Wasn't didn't you ask him if, I could have sworn that you said that you asked him whether or not he would give a sworn recorded statement, not just a recorded statement, or am I recalling that incorrectly?
I think in front of the jury, the question was recorded statement, but I think in our proffer, Lieutenant Levitt said sworn recorded statement. And I'll have to defer to the record, but I know it was slightly different. The question, I asked a slightly leading question when the jury was in the box, and I asked a more open-ended question during the proffer.
Judge, could we have
We'll let the stenographer take a look. We'll give her a moment, see if she can pull up exactly what was asked in front of the jury. Sorry.
Ready? Question, were you able to make a recording of that discussion? Answer, no. Question, why not? Answer, he refused to provide a sworn taped statement. Is that all you need?
Yes, ma'am. Just let me know when you're ready again.
I'm ready now.
Okay. Anything else?
Judge, based on that statement from Lieutenant Levitt, he has not testified in this trial. That's being offered as substantive evidence, and we are asking that we're moving for a mistrial in this case. I would also like to cite Smith versus State, 754 South 2nd, 54. That's a 3rd DCA case. Judge, in that case, the defendant responded to a few initial questions and then refused to give a stenographic statement. The Smith panel viewed the record. Smith was not being asked to memorialize what he had already said. Instead, Smith was being asked to make a further statement before the stenographer. In refusing to do so, he did invoke the right of silence. We feel that this is an improper comment on the defendant's right to remain silent.
Okay. Your objection's noted for the record, overruled. I'm going to deny your motion for a mistrial at this point. I'm going to instruct the state that they can to move on from this line of questioning, 1. 2, if it's brought up again, I would steer away from anything about a sworn statement. Just if he declines, he declines.
Yes, Judge. And will the court allow the state to inquire into the discussion that the lieutenant had with the defendant prior to being asked to provide the recording?
Yes, sir.
Okay. I'd like to make sure that I've admonished the witness not to mention that the defendant, at the end of the statement, indicated he did not want to talk anymore.
We go through what you're exactly going to ask your witness here at the very end again.
The question that I want to ask is, did you have an opportunity to talk to the defendant? Yes. Were you able to record the discussion? No, he refused to record recording.
I think that's already, that cat's already out of the box, isn't it?
Well, yes, but the objection from the record, I think if you read that record where the objection started, I never got to go further. When the officer said he refused to provide a recorded tape statement. Well, yes, but he did make a statement, and I think that's the part that's not on the record before the jury. That I want to make the record that he did provide a statement. It just wasn't sworn. It just wasn't recorded in tape.
Well, I think all you need to do then is ask him, did he make a statement?
Okay.
And Judge, again,
Right.
I'm sorry.
Yes.
Go ahead.
That the cat is out of the bag, and that's why we're moving for a mistrial.
And I denied that. Okay.